there is not 1 month without a new suspicion of corruption implicating a French company. Anti-corruption in France, very simple. Before 2016, no prevention, no prosecution against acts committed abroad. And this is one of the main reasons why France had a bad reputation, had a reputation of not doing enough efforts to prevent and to fight corruption. Things changed in 2016 with an alignment of France with best international standard, and that is the adoption of the 2016 Act. It is called the Sapin II, Sapin being the name of the member of the parliament at the origin of this act. So what were the changes in 2016? I've listed 6 of them. We're not going to run through all of them in details because we don't have enough time. So these are the 6 major changes, and let's just start and see each of them. Okay, so first change is enhancement of, increased sanctions for corruptions. I have inserted in my slides some definitions for those who are interested in that. And you'll see that the maximum sanctions are 10 years of imprisonment and 1 million euros fine for individuals or companies which are convinced of corruption. So I'm not going to go into details, just surprisingly, not all corruption acts have the same sanctions, and personally have difficulties in understanding that. For example, if you pick up favoritism, you see that it's only 2 years of imprisonment, 200,000 euros, and I just don't see any valid reason for that, because in terms of damage, in terms of economic consequences, favoritism is probably as severe as bribery or as misappropriation of public funds. In terms of sanctions, you should bear in mind that what is really new since 2016, and to be more precise, it's since 2017, because the new act entered into force, I think it was in January 2017. What is new is obligation that can be made to a company to implement an anti-corruption plan. It did not exist before, and this obligation may be ordered when a company is convicted of course, a corruption, but not only, also of connects crimes. Okay, so the major change that occurred in 2017 is the creation of the French Anti-Corruption Agency. I have listed here its main missions, which are to inform the public, help in preventing corruptions. And in this respect, the agency is due to make recommendations. The agency has worked for 4 years now. It made recommendations in 2017, and very recently, and I will speak about that a little later. Very recently, last January, the agency issued new guidelines for corruption prevention. So it's not a full-time job. So when the agency is not drafting guidelines, the agency is conducting controls. And again, this is also a major change in French law. The agency has the right to control any company which is subject to the obligation to have an anti-corruption plan. And we'll see in a minute what companies this refer to. And that's the first situation where a control can take place. Second situation is when, as I said earlier, a company is convicted of corruption and the criminal court orders this company to adopt a prevention plan. Generally, the obligation to adopt the plan will be executed under the supervision of the French anti-corruption agency. And this is a large part of its work. And of course, the fact of not implementing a plan can be fined with 200k euros and up to 1 million euros for companies. The last mission is, of course, to report offenses to public prosecutors when controlling a company, an act of corruption is being detected. So as I said, the company has been working now for 4 years, and what is the result of that? Well, as a matter of fact, it's not very satisfactory. There's a lot of criticism around the agency. And one of the reasons being that the number of controls which have been conducted in 4 years. 125 controls, provided that in France, there are about 200 companies, 2,000 companies, not more, which are subject to the obligation to have an anti-corruption plan. So if my math is correct, that's roughly 5% of the companies that were due to implement a prevention plan in 2017, only 5% have been effectively controlled by the agency. So that's not much. Does that mean that the agency is not working? No, not really. In fact, the agency does work and works very hard, but it's probably the way it's working that is subject to criticism. Companies who have been controlled by the agency have testified that the controls were very long and very heavy. They also have reported that the agents which are conducting controls don't have the background which fits with such control. Most of the agents are former members of the French Ministry of Economy, and they are not always persons who are aware of economic environment. I mean, in terms of commercial companies, and so it has been reported that their controls are sometimes very theoric. And this is clearly a problem, and this is clearly a source of criticism against the agency. Another aspect of the 2016 Act, but I'm not going to say a lot about it, is protection of whistleblowers. This is something you are probably already familiar with. You should just bear in mind that as of today, the protection granted to whistleblowers is probably not sufficient, because the only persons who are effectively protected are employees. French labor law has been amended also in 2016 by the same act, so as to prevent companies to order sanctions against employees who would have revealed informations about corruptions. But again, it is considered now that this is not sufficient. This protection, it does not suffice to this point. Okay, so here we are now, I'm going to talk about anti-corruption plan. I said this is the main change in French law in 2017, is the introduction of the obligation to prevent corruption. You see, the companies which are concerns of French companies, that means companies having their head offices in France and having more than 500 employees and 100 million euros. As I said, this represents less than 2,000 companies in France today. For these companies, it is mandatory to implement an anti-corruption plan. There's a sort of discrepancy, because remember in the introduction, I was saying that corruption refer to at least 6 criminal acts. But the anti-corruption plan is only due to prevent bribery and influence peddling. But this is only a formal restriction, I think, because, of course, internal process helping at preventing bribery and influence peddling will most likely help you to prevent other acts of corruption. So, anti-corruption plan, what is a plan? Well, French law provides that a plan should be composed of the 6 items, and I would like to draw your attention to items 3 and 4. The report from the agency after 4 years of activity shows that in a large majority of cases, item 4 was missing. That means that companies who had adopted an anti-corruption plan had forgotten to conduct a third-party due diligence. So what is a third-party due diligence? It is the obligations to check who you are doing business with. And so for those who would be concerned, a good idea could be to speak with your insurance department if you have one, because they probably already run a third-party due diligence just to see and detect what the risks were with your foreign suppliers, for example. But the most problematic item is probably item 3, is risk mapping, because there are an infinite number of ways to do a risk mapping. And this is where all the subjectivity of the French law relies. It means that when you will be controlled by the French anti-corruption agency, there will be debates about the efficiency of your risk mapping. And experience shows that the views of the control company and the views of the agency are never the same. And you have to bear in mind that the result of all this is that if it is found by the agency that your risk mapping was not relevant, you will be ordered a fine, potentially. Okay, another change into French law was the introduction of the deferred public prosecutor agreement. This is something which is probably very familiar to Anglo-Saxons, but this was really a novelty in France in 2017. So this is an agreement which a prosecuted company will enter into with the public prosecutor. Bear in mind that it can be entered into either at the beginning of the prosecution or during the court trial under very restrictive conditions. So in most cases, it is being entered into at the very beginning of the criminal process against the company. This agreement has to provide for at least one of the 3 obligations that you see on the slide. And I would like to draw your attention to the fact that the agreement will have to provide for the payment of a fine which is capped at 30% of the turnover of the prosecuted company, which means that the amount of the fine has nothing to do, it cannot be compared with the amount of the fine had the case been prosecuted in court. And you will see with some examples that I will show you in a minute that the amounts of the fines in DPAs are way above the amounts that is being due in case of criminal prosecutions and in criminal convictions, sorry. So it costs more money, but what do you get in return? Well, again, this is probably something you already know. In return, no trial, no conviction, and no registration on the criminal record. So is that satisfactory for our clients? Well, not really, and for 2 reasons. First one is that when you will enter into a DPA, there will be a press release. This is what French law says. But a press release is one shot. But apart from the press release, the DPA itself will need to be published on the French agency's website. And if you go check their website, you will see that there are currently 7 DPAs which are accessible to anybody, freely accessible on their website. And when I mean the DPA, it's the entirety of the agreement. It's not just a copy. It's the entire agreement where you will find all the facts at the origin of the prosecutions, where you will find the amounts of the profit which the prosecuted company gained from committed corruption. So you will find all the information about what has been going on. So there's no confidentiality. Here are examples of DPAs which are currently on the website of the agency, and you will see that the amount of the fines have nothing to do with what is being provided for in the French criminal code. You will see also something which is very interesting is the amounts of the compliance program. As I said earlier, a company being convicted with corruption will have the obligation to implement an anti-corruption plan, but it will have to do it under the supervision of the French agency. And French law even provides that this supervision can last up to 5 years, which means during 5 years, you will have to show and you will have to respond to inquiries, to questions raised by the French agency. This has a cost, and when entering into the DPA, the convicted company has to pay the amount of this control. And for Bolloré, this amount was 4 million payable in advance. For Airbus, the amount was 8.5 million euros. So again, if my math were correct, in the case of Bolloré, the cost of the control, of the supervision control, was roughly 33% of the amount of the fine itself. So some say that it's like a second fine which is being ordered against a company, notwithstanding the fact that during 2 years for Bolloré, 3 years for Airbus, you are obliged to open your books, to open your files to the French agency and to answer any question. And in addition to the cost which is being paid, which I would call external cost, there is an internal cost for these companies. And in average, companies consider that in addition to the amount to be refunded to the agency, the cost of a supervision of a control from the agency is in average 285,000 euros. So that's large amounts. So second last change made in 2007 is the global reach of French law, I could call it, because prior to 2017, French law would only apply to crimes committed on the French territory. So this is not the case anymore. There are no restrictions anymore against prosecuting acts committed abroad. Bear in mind that statistics show that the most prosecuted corruptive acts during the 5 past years is bribery of foreign public officials. So it's clearly something that would not have been prosecuted in France before. It is now possible. Another change also is that French criminal law now applies to individuals or foreign entities which live or have economic activities in France. And last but not least, introduction in French criminal law of bribery of foreign public officials. And as I said earlier, this is a very common offense, which is now being prosecuted in France and also in other countries. And echoing on what has been said earlier, this is where international cooperation is very important. Just one precision about change number 2, I insist on that. Criminal law is not applicable to foreign entities. But when I say criminal law, I'm not talking about the Act of 2016, which means that foreign companies remain unobliged to adopt an anti-corruption plan which would match French requirements. This is still only applicable to French companies. Okay, so that was for the changes introduced in 2016, 2017. So what is going on now in France? As I said earlier, in January 2021, the French Anti-Corruption Agency issued new guidelines on prevention of corruptions. And yeah, we'll see in a minute that these guidelines incur major changes. One word about these guidelines. They are not mandatory. A French company is free to adopt them or not. However, the French agency has stated that the mere fact of adopting these guidelines will be equivalent to having a prima facie presumption of compliance. In other words, the fact of not adopting the guidelines issued by the French agency will lead a company to have the burden of proof that its own prevention plan does comply with French regulation. So as a lawyer, we can only recommend to a company to adopt the agency's guidelines. The problem is that most of companies, well, not most companies, but a large number of companies did so and decided to adopt the 2017 guidelines. So for these companies, the question arose some weeks ago, and the question was the following. Having adopted the 2017 guidelines, should they now change and adopt the new guidelines? The answer is yes, and for the reasons we're going to see now. If you remember, I said earlier that a prevention plan is composed of 8 items. Well, that was until January 2021. The French agency has totally reordered its guidelines. Now, instead of 8 items, we have 3 so-called pillars of anti-corruption, being provided that the first pillar is something totally new. It's not even in French law. It's something which has been created by the French agency. So there are some, doubts about the legitimacy of such pillar. But anyway, if you don't want to be controlled or if you don't want to be fined by the agency, you rather take this into consideration. And this pillar is very important. It's about senior management commitment to run a business in a proper manner. In other words, the French agency now requires that French companies, senior management, being involved in a day-to-day basis in anti-corruption. The second pillar, we already spoke about it, is risk mapping. So you see it's becoming even more important as it is now one of the 3 pillars of anti-corruption. And the third pillar is, well, the 7 remaining items that were already in place in 2017. So apart from this total reordering, other changes are the enlargement of the scope of the guidelines. The guidelines now are due to guide not only companies which are subject to the obligation to implement an anti-corruption plan, but to any company, which means that let's imagine that a very small company is being convicted of corruption, and let's imagine that the criminal court orders that company to adopt an anti-corruption plan. Such plan will have to match the new guidelines. And it may sound something very easy to do, but in practice, it has a cost, as I said earlier. And for small companies, this can be a major issue. Building an anti-corruption plan which complies with the 3 pillars identified, shaped by the French agency can be very difficult. Okay, so apart from these new guidelines, also since the beginning of the year, the 2016 Act is being assessed by the French Parliament. I have followed the debates that took place earlier this year. I think it was in April and May. Two members of the parliament have been appointed to make auditions, to make interviews. And one of the person interviewed being the director of the French anti-corruption agency. And needless to say that the debates were relatively and surprisingly intense. And I will say a few words about that, but it would seem that the French parliament is in favor of another change in law. So the report on this ongoing assessment is due to be filed at the end of the year, and we don't know what the conclusion of it will be, but we have some clues about the changes that will maybe figure in it. First change that the report will probably point out is the necessity to enlarge DPAs to directors and officers. However, there are many debates about that because there are, pros and cons. The pros is that we think that not including directors and officers in the DPA may discourage them from disclosing acts of corruptions because they will not be protected by the DPA. The cons is that some people consider that including directors and officers in the DPA will encourage a relapse of corruption. And as a matter of fact, a survey has been conducted in the US, I think it was 2 years ago, and it appeared that 40% of corruption relapse was implicated directors and officers who had previously entered into a DPA. So 40%. So some people consider that this will only encourage relapse instead of discourage disclosure of corruption. Another expected change in law is, and this should be a point of concern for our participants today, is the enlargement of French law to foreign companies operating in France. You remember I told you that the obligation to have an anti-corruption plan only apply to French companies. Well, tomorrow it could well be that also foreign companies will have the obligation to have an anti-corruption plan. So you're going to say to me, well, that's not a problem because mostly international companies do have an anti-corruption plan. Well, yes, of course, but that plan will need to match the French agency guidelines. And so it is very likely that even if they already have a plan in place, this plan will need to be revised. In other words, there will need to be a French version of their anti-corruption plan. As a matter of fact, one of the two parliament members in charge of assessing the law is a person I know personally. And so I recently had a conversation, and it would seem that they are, for the time being, they're rather in favor of merging the French anti-corruption agency with another French administrative authority, which could be a very bad sight in terms of anti-corruption. But the problem is that, again, I think I made this point rather clear to you, is that the agency in 4 years has not done enough, or in a manner in which it would now be recognized as a French anti-corruption authority. It's a very young agency, but the 4 years of work were not enough to have it being recognized by other French authorities as being a major actor of anti-corruption. So some people are in favor of its closing or of its absorption by another authority. Okay, last point, and I will be through with that, is France is due to transpose the Whistleblowing Directive of 2019. And as you know, EU members are entitled to go beyond the directive, to do more than what will be required by the directive in terms of whistleblowers protections. And you'll see on my slides the reflections that are ongoing to increase that protection. And among these reflections is the financial and psychological assistance to whistleblowers, being provided that financial assistance is a point of very intense debates in France for the time being. So, well, that's it. So just if you should just have one point in mind is that in a very near future, it is very likely that foreign companies operating in France will need to care about compliance in France. So it's time to work on compliance for these companies.